So what have been the effects or the consequences of the Human Rights Act? 1998, the Human Rights Act is passed by Parliament, and in 2000 it comes into effect. What the Human Rights Act does is it takes the European Convention on Human Rights and incorporates it into British domestic law. And that has a fairly dramatic effect. Now, instead of taking many years to go through domestic courts in order to seek redress eventually from the European Court of Human Rights under the Human Rights Convention, instead, you can have those rights available to you, seeking redress through judicial review or other court processes in your domestic courts. So it's available to all British citizens now. So their rights are hugely enhanced in the sense they're made much more accessible. The other effects of the Human Rights Act is that the European Convention on Human Rights now becomes a guidelines for all British courts and institutions. So institutions, education institutions, the police, the civil service, local authorities must behave, must issue regulations, must observe and consider the rights that are protected under the Human Rights Act and by extension the European Convention on Human Rights. The other thing is that courts themselves must, wherever possible, interpret laws. Pre-existing laws made in the past, the body of case law and common law must now be interpreted by courts in line with the Human Rights Act or the rights therein. If it is thought they couldn't be, if there is a pre-existing law or a law made by Parliament which is considered incompatible with the rights in the Human Rights Act, then a declaration of incompatibility can be issued by the courts, and the government is obliged to either introduce new legislation or to amend existing legislation to make it compatible. So this has changed in many ways. It has changed the legal landscape of this country, introducing new rights in a sense, but above all, making them altogether more available and useful in new ways by citizens. Well, the consequences of this, as any American will recognize, is that judges have started to interpret, since interpretation is their job, interpret these rights in new ways, to the extent they might be seen to develop new rights that aren't necessarily clearly found in English law or British law, and by extension, they become by this process, the judges become sort of quasi-legislatures. It was in a famous case of Griswold versus Connecticut that the Supreme Court found in the shadows or the penumbras, as it were, of the Constitution or the Bill of Rights, they found the right of privacy. William O. Douglas describing this as found within the penumbra of the Bill of Rights. Well, if you can find a right of privacy inside the Bill of Rights, by extension things like searches and seizures and so on, and rights to silence, personal right to silence, the Fifth Amendment, if that can lead you to extrapolate a right of privacy, and asserting that in the Griswold v. Connecticut case, that married couples had a right of privacy in their use of contraceptives, and that by extension can then establish a principle by the process of stare decisis on which future cases can be judged, leads to Roe v. Wade. In other words, women have a right to an abortion since their bodies are private to themselves and are sovereign to themselves. Well, you can see that much to the dismay of many American, religious-orientated Americans, was a court going beyond itself and legislating and finding rights which weren't there. So the British courts can be accused of something similar, certainly developing new rights, particularly in the area of privacy, in the Max Mosley case, in the Michael Douglas case, in cases which have limited the way the police can keep data records on suspects and people they've questioned and so on, keep data generally, have all developed what might be considered new rights. For example, in the case of Gaidan versus Godan Mendoza, here were a couple, of same-sex couple, who one of them having deceased, the question was whether or not the other one could inherit the tenancy of their rented accommodation. And this would be true if they'd been married, but since they weren't married, could they inherit? And the courts judged that existing laws should be applied in line with rights to family life, to how you lived. If you lived like a married couple, you looked like a married couple, then in effect, you had the rights of a married couple. So rights were being expanded, extended, possibly invented, found, maybe in the shadows of the European Convention on Human Rights, some have started to develop a rights culture in this country. So other legislation, such as the Freedom of Information Act, Data Protection Act, and the Equality Act, all of which seem to follow on from a sense that Britain was developing something like a rights culture, which may have seemed to be originated from this sort of seismic shift in the adoption of all these extra rights, or the availability of all these extra rights into English law. So something had shifted in the judicial culture as well as the processes.
The Human Rights Act protects you in all areas of life, such as your right to an education, a fair trial, and to freedom of expression. If your rights are breached, the courts can enforce them. Here are some cases that have involved the Human Rights Act. Families affected by the Hillsborough disaster used the Act to present evidence to a jury in a new inquest. This revealed that mistakes made by the police and others had led to their loved ones' deaths. Mrs. Ueda, a British Airways employee, was prevented from wearing a visible Christian cross with her uniform. She used the Act to prove her right to religious freedom had been violated. The airline changed its policy. A Do Not Attempt CPR, cardiopulmonary resuscitation notice, was placed on Mrs. Tracy's medical notes without her knowledge. This breached her human rights, and health workers now have to involve patients or their families in any decision about DNA CPR notices. After the death of his partner, Juan Godin Mendoza pleaded that gay couples should have the same tenancy rights as heterosexual couples. The Supreme Court decided that courts need to read the phrase surviving spouse in the Rent Act as including the surviving partner of a same-sex couple, even before same-sex relationships were legally recognised in the UK. Mr. and Mrs. Driscoll had lived together for over 65 years. Mr. Driscoll was moved into a residential care home. Mrs. Driscoll was told she didn't meet the criteria to live there too. This was a breach of the couple's right to a family life. It was reassessed and the couple were reunited. Jan Sutton had multiple sclerosis. The council only paid for carers to make short visits to her home. The rest of the time she was confined to her bed. Jan took legal action under the Human Rights Act to secure better care from the council and won. As a result, she was able to enjoy a better quality of life. She became a committed campaigner for human rights until she died. If you are worried that your human rights have been breached, contact a solicitor or the Equality Advisory and Support Service for advice.
The effect of the Human Rights Act has been an increase in the number of judicial review cases that get it. Subsequently, judicial review cases have declined somewhat since the government have changed the rules to do with legal aid and it's become more expensive to launch judicial review cases. And the kinds of judicial review cases that can be heard have also been redefined. So the increasing use of judicial review has plateaued and declined somewhat. But nonetheless, in historic terms, judicial review has become much more a feature of British judicial processes. So, in choosing to incorporate the European Convention on Human Rights into British law, and yet remain a signatory to the Council of Europe and the European Convention on Human Rights, leaving that avenue open as well, it was a dual process. Now, initially, when the European Council and the European Court of Human Rights operated, there was a doctrine which was known as the margin of appreciation. In other words, the European Court of Human Rights and the Council of Europe would appreciate the fact that in different countries, cultural and historical and judicial cultures, there would have to be we'll call it a margin of appreciation. They would appreciate that there should be a kind of flexibility to how the rights of the European Convention of Human Rights were applied across Europe. There was all these different countries and cultures and histories. An accusation which emerged was that the European Court of Human Rights began to not observe this so strictly and instead began to see themselves as enforcing something of a living document, that the rights that the rights contained in the Convention of Human Rights were a living instrument, that it should be updated. And this, of course, any American will be familiar with this debate between the kind of strict constructionalists and the loose constructionalists, between the originalists and those who say the Constitution is a living document. And of course, if it's not a living document, it becomes a fossil. And if it is a living document, then it means what the latest set of judges tell you it means, and so on. So this is a problematic area of bills of rights. Again, do they move, adapt? Are they flexible with the times and changing attitudes? Or are they an immovable statement of something that was originally intended by the drafters of the Constitution, in which case they become increasingly out of date and irrelevant? Well, that debate, which is such a clear judicial debate in the United States, has also emerged with the European Court of Human Rights, how it applies its own understanding of domestic law. Cases where, for instance, the British found themselves losing a case in the European Court of Human Rights over not allowing prisoners to vote. It was considered a right to vote. It was a human right, even for prisoners in prison and so forth. Whereas prisoners in the UK couldn't vote once they were once they were locked up in prison. Similarly, the use of whole life sentences, fairly rare in this country, very common in the United States, but fairly rare in this country. Whole life sentences with no possibility of parole was considered an infringement of human rights. Well, both of these cases led to accusations that the European Court of Human Rights was ignoring the principle of marginal appreciation and has started to assert, as it were, this kind of living document, living instrument kind of philosophy. They were becoming, in other words, increasingly activist judges. Actually, both of those cases were sorted out, as it were. Britain managed to apply a kind of compromise arrangement over prisoners voting and over the ability, in theory, for people given whole life sentences, there was still the possibility they could be released under certain circumstances. And the European Court was, in the end, satisfied with that. So the accusation that the European Court of Human Rights stands in the way or has become more activist, well, some say it has.
I've got no problem at all about the text of the convention. I do have quite a serious problem about the way in which the text has been treated by the European Court of Human Rights in Strasbourg. Since the 1970s, they have operated in accordance with what they call a living instrument doctrine. And that essentially has been treated as a way of expanding on the text by a process of extrapolation and analogy, so as to produce a very large number of rights, some of which are loosely ancillary to existing rights, but many of which are freestanding. I think that this is an essentially legislative process and involves a usurpation of the function of democratic legislatures. We do not need the Human Rights Convention in order to protect human rights, but I certainly wouldn't like to see it abolished unless we replace it with something equivalent. So what I would suggest is that we should replace it with something that would look very much the same as the Convention, but which would not be subject to the jurisdiction of the Strasbourg Court.
And some say it hasn't. So while the European Court may or may not have been changing with the times, seeing its role as altering, society certainly has changed. In 1948, 49, 50, when the European Convention of Human Rights was being drafted, their view of the world was governed primarily by the lessons learned from the 1920s, 1930s. And one of those lessons had been that it was particularly necessary for citizens to be able to seek asylum. In the 1930s, countries had refused entry, largely, with a few exceptions, children and so on, to Jewish people fleeing persecution in Germany. It was seen as a great lesson from history that the right to asylum, someone seeking to escape persecution, should be honoured as a universal Right. Well, that has come to dominate the political landscape in Britain as we speak. And so when it comes to Jack Straw and Nigel Farage and David Blunkett arguing, or Malcolm Rifkind arguing that there's a problem now with the Human Rights Act, they are thinking primarily of immigration, of people entering the country irregularly in small boats, or large numbers of immigrants who overstay their visas or overstay their student applications, their student period of education, and so on. So controlling immigration, the Human Rights Act has come to be seen as a problem. And indeed, Theresa May famously said that you couldn't deport someone, the courts would prevent you deporting someone because owning a cat was seen as a human right or part of family life. And the press had reports of deportation being refused because of someone's child didn't like the kind of chicken nuggets they could obtain in another country. Largely, these were exaggerations. Since 2022, it's been a criminal offence to arrive in this country irregularly by boat, as it were, not through the normal processes of seeking asylum. And since 2022, an application for asylum will be considered less favourably if you've arrived in this country in an irregular way. While there are thousands of cases, backlog of cases of people who are appealing for the right of asylum or appealing against judgments against the right of asylum. And part of the reason for that backlog is the slowness of the courts, the difficulty, the due process that takes place, the rights of appeal and so on. There are all sorts of other reasons why it's hard to deport people or hard to limit immigration, and not least of which is people arrive in this country with few documents. It's not clear where they came from. And most immigrants coming to the UK and seeking asylum come from countries where it's recognised they would indeed be in danger of persecution. So whether it's perception or whether it's reality, and there certainly is a reality to the length of time it takes court processes to take place, the Human Rights Act has been seen as a problem or an obstacle to addressing the problem of immigration. And immigration, whatever your views about immigration into the UK, it's certainly become a hot political issue. And it's something which is dividing parties and dividing people all over Britain today. And indeed, the latest opinion polls show that immigration and concerns over immigration are the top issue in the country, above education, above health, above housing, above the economy even. It is immigration that concerns people the most. So it's an extraordinarily polarizing issue. And the Human Rights Act has found itself as either as a useful scapegoat for this problem or an actual practical obstacle to dealing with it. If the Human Rights Act were abolished or replaced by a British Bill of Rights, you might argue it would contain pretty much the same sorts of rights as the original Human Rights Act and European Convention on Human Rights, since they were designed along the lines of British rights anyway. Whether there'd be a lot of difference between a British Bill of Rights and a European Convention on Human Rights, it's hard to say. Would they contain fewer positive rights to family life and so on, which seems to be the one most people focus on? Or would it be narrower, just a few, rather like the American Bill of Rights, would be much narrower, negative rights, just to be left alone, a kind of Bill of Rights of neoliberalist Bill of Rights, as it were, be left alone to enjoy your property and your freedom to express yourself and so on. Whether that would be the case, it's hard to say. And if you did withdraw from the European Convention on Human Rights, besides what would be called these days the optics of that, besides that looking rather bad for the UK as a country which has always prided itself in its soft power of reputation of rule of law and judicial systems and a free country, as it were. We're a free country. Brits like to say that about themselves. Whether withdrawing from this internationally recognized Council of Europe, I mean, us and the Russians and the Belarusians had withdrawn from the Council of Europe. Not a good look. And if we did withdraw from the Council of Europe and the European Convention on Human Rights, it would create problems for Northern Ireland, since the Good Friday Agreement is explicitly underpinned by the kind of rights that are expressed in the European Convention on Human Rights. So that would have to be, some exception would have to be made for Northern Ireland. And there would be problems with Brexit, since our relation with the European countries and our ability to participate in cooperative agreements over security and other issues are underpinned again by a shared recognition that we have within the European Convention on Human Rights. So leaving the European Convention on Human Rights is going to be problematic, is going to be difficult. Suspending bits of it, possibly less so. Replacing it with the British Bill of Rights may be no great change from where we are now. The 1951 Refugee Convention, we're bound by that when it comes to asylum, not just the European Convention on Human Rights or the UN Universal Declaration of Human Rights, which also recognizes a right to asylum. And of course, the fact that the majority of asylum claims are granted, since they come from countries which are recognized as places where they have a justifiable reason to feel they would be persecuted or in danger if they were returned. And that would undoubtedly still be the case within or without the European Convention on Human Rights.